Good morning, all. And today's video is about, again, Neurotranslator. And it's about my case in which I was punished by a United States Magistrate, the Honorable Gary R. Jones, and the then Chief United States District Court Judge for the Northern District of Florida, the Honorable M. Casey Rogers. And they sanctioned me over $40,000 in the absence of providing me any autism language translator. And so I want to go over what happened and how I was misinterpreted, because Neurotranslator has given some feedback and insight on that. That case was started as Petranos v. Old Republic National Title Insurance Company, and in the middle of the case, the court changed the name to Petranos v. Nationwide Insurance Company, and the case was in Gainesville, Florida. And so here's some of what happened. Now, Nationwide was not communicating with me very well, okay? And even though I had been in a rear-end car accident where I was a passenger in a car that was driven by my husband, and he was stopped at a railroad crossing while a train was passing by, and this idiot came flying out of nowhere at about 45 miles an hour, didn't even seem to try to stop, and slammed into the back of our car, and my seat restraint broke on impact. Okay? So the first thing is that the man's name was Antonio D'Angelo, and he was insured by State Farm Insurance Company. Now, State Farm Insurance Company decided that I had a valid claim for personal injuries, because ultimately I had over $100,000 in medical bills from this, and that's when I ran out of the money to pay the medical bills. And they were doing the diagnostics, and I needed treatment, and I couldn't get the treatment because first State Farm paid, but State Farm had a bodily injury part of their policy, and D'Angelo and his wife suffered injuries in it, as well as my husband and I, and so they basically split the amount between us, which certainly did not cover my more than $100,000 in medical bills. And so my husband and I had underinsured motorist coverage with Nationwide. And so even though State Farm made a determination that I had a valid personal injury claim and paid on my claim and up to the full policy limits, which was split 4 ways, as I said, Nationwide, all of a sudden, even though they, under Florida law, were only allowed to step into the shoes of State Farm so that they could only raise any defenses to payment that State Farm could have raised or did raise or something like that. But Nationwide decided to take the position it wasn't going to pay at all, and they started misinterpreting me and miscommunicating with me. At one point, they had an insurance representative on it named Earl Charles Law, and on a phone call with me, Earl Charles Law, I asked him for Title II American with Disabilities Act reasonable accommodations for my autism in order to be able to communicate effectively with Nationwide about my claim. And Mr. Law came back and said, the only civil rights that matters is the black civil rights, and there's no ADA civil rights, and we're not accommodating you. So it was an impasse. I wasn't able to get anywhere. My husband grabbed the phone and started trying to tell Mr. Law that I needed accommodations because I was autistic. So what I did is I couldn't get past this Mr. Law and the impasse. So what I did is I sent a letter to Nationwide to the Registered Service of Process Agent's address listed in the Florida Business and Corporation records. And what that did is, again, Nationwide misinterpreted me. So they hired basically, I think he was a Kumis counsel. They hired a lawyer to communicate with me and with Nationwide and sort of for me, because certainly in the records, later records, in a records response with the University of Florida Autism Card Center, they were describing this lawyer as my lawyer and me as his client, but his name was Carl Schwait. And Carl Schwait's background was that he had been the chairman of the 8th Judicial Circuit of Florida Attorney Grievance Committee, one of their grievance committees, and he had been something like co-chair of the Florida Bar's Disciplinary Committee. And so then what happened is Mr. Schwait wasn't really getting it or clued in about my autism spectrum disorder. And so we had a lot of go-rounds back and forth over that. And he just basically, initially, ultimately took the position that he didn't have to change anything to accommodate me. And so, tough shit. So I wasn't getting paid. And my chiropractor, Chris Langhires, in his office, told me, you have to sue Nationwide. This is a valid claim, and they should be paying this claim. And they gave me a business card. It said, here's a lawyer you can go to. And the business card was for Tom Carey of the Tampa area law firm Carey and Leisure, PA. So I called Mr. Carey, and he talked to me for a long time, half an hour about my case. And he told me I have a valid claim, but that he can't handle clients who are autistic. So I was going to have to sue myself, or I could go to Morgan & Morgan and see if they are able to represent an autistic person. Of course, when I tried to call Morgan & Morgan, they just blew me off. So ultimately, the statute of limitations was going to run. So my husband and I filed this lawsuit to try to get Nationwide to pay. But one of the common issues among the defendants was that none of them were accommodating my autism disability. And so we sued, and so the case eventually was renamed as Petranos v. Nationwide Insurance Company. So the first thing that happened, now I'm autistic. I have a bottom-up information language processing style. It's innate. It is an inherent and invidious trait of my autism. And I'm detail-oriented. So it's complex, detailed-oriented language communication. And so I drafted a complaint with my husband. We worked on our parts and then put it together. And so the next thing that happened was Carl Schwait hired a law firm, Banker Lopez and Gassler, PA, in Tampa, Florida, and an attorney named Trevor Rhodes, Esquire. So Trevor Rhodes filed on behalf of Carl Schwait a motion to dismiss my claim. And here's what Mr. Rhodes and Mr. Schwait argued. Furthermore, plaintiffs have themselves set forth in the complaint that they have law degrees, with David Petrano having passed the bar in Florida and Mary Catherine Day Petrano having passed California's bar. Other courts have also recognized plaintiff's background as significant to include a legal education and bar licensing, but yet a long history of filing abusive and frivolous claims, thus precluding the ordinary rules of liberal construction afforded pro se litigants. And that was defendant Carl Schweight's motion to dismiss. Now, that neurotypical Florida bar member Trevor Rhodes and other Florida bar member neurotypical Carl Schweight's misinterpretation of my autistic language communication resulted in a United States Magistrate order. And that order was rendered by a U.S. Magistrate, the Honorable Gary R. Jones. This is, at this point, the only copy I have, and so I'm told it's hard to see. But Magistrate Gary R. Jones made the following fact-finding and footnote number 1 of this document in the case. David Petrano has been a member of the Florida Bar in good standing since February 2003. Although Mr. Petrano is not currently a member of the Bar of the Northern District of Florida, Mr. Petrano is representing himself in this case. Mary Catherine Day Petrano is a member of the Bar of the State of California, but has not requested permission to appear in this case pro hac vice, and instead is representing herself. Thus, while both plaintiffs are attorneys, they are deemed to be proceeding pro se. Now, first of all, I have never been a licensed lawyer anywhere one day in my life. And I have never told anybody that I ever was. So, those words and representations that resulted in this magistrate order saying that I was a bar member and an attorney did not come from my mouth. They came from the neurotypical misinterpretations of my autistic language communication by Florida bar members Trevor Rhodes and Carl Schweight. Because the only thing I ever told them was that I had graduated from law school in 1990 and that I had passed the July 1997 California bar exam. Now, I don't know why they didn't check the membership records of the State Bar of California to actually verify their neurotypical inference-based language interpretation of my autistic literal fact-based language. But apparently they did not. So there's that magistrate finding, and that magistrate finding still stands to this day uncorrected. So, next, I had asked the Honorable U.S. Magistrate Gary R. Jones for an autism language interpreter translator. And he misinterpreted and misunderstood my autistic language communication. And he said that, well, if there's ever a spoken in court hearing, he would provide me an autism language interpreter. But I asked for an autism language translator as well, and that was never provided to me. Now, one thing that's known, and it certainly is discussed in detail on Facebook on Bill Nason's autism discussion page, and that is about what happens when neurotypicals use their social inference-based language upon an autistic person's literal fact-based language, and how it causes just almost 100% misinterpretations and misunderstandings of the autistic person, especially the autistic person's intents and motivations. And so I was completely not understood in any part of that court case before the Honorable U.S. Magistrate Gary R. Jones or the Honorable U.S. District Chief Judge M. Casey Rogers. And so here's how Magistrate Jones described his perception of my different autistic language. Confusing and rambling allegations, replete with irrelevant and unsupported factual allegations and legal conclusions, and plagued by incomprehensible and truly puzzling statements. The court is forced to sift through various irrelevancies and myriad word puzzles to distill what it is exactly that plaintiffs intend to place before the court for resolution. An onerous task which the court is unable and unwilling to perform in this instance or any other instance. The court also said defendants Nationwide and Schwait have put forth a valiant effort to decipher plaintiffs' claims in order to assess their legal merit or lack thereof. Now, I complained quite a bit about this deciphering idea because I had asked for an autism language translator, which I didn't get in that court. And so the idea to me that the opposing counsel would be deciphering my fact-based autistic language when they already had proven in the past they were not able to do it without misinterpretation or misunderstanding. And they didn't appear to have any autism educational training or experience. So after I started complaining about that they were deciphering, which to me is another word for translating, the U.S. Magistrate tried to be dismissive of that and say, well, I don't think it really meant they were deciphering for the court. But, I think that's exactly what they were doing. Because that's what it says. It says right here, decipher. Okay. So I put an inquiry in to Neurotranslator, and it outlined all of that and what occurred in this neurotypical versus autism language communication difference that caused this just craziness and misinterpretations and misunderstandings of my autistic language, and resulted in not only our claim becoming dismissed, despite that my doctors and another Florida bar member had advised me that I had a valid claim. And to interject another note, that Nationwide and its lawyers then, subsequent to this, filed a Florida bar complaint against my husband, David Petrano. And one of the counts was this Nationwide case that we lost on the basis of the description of neurotypical perception of my autistic language being described that way, like a myriad of word puzzles and truly puzzling statements and things. I mean, it's like, are those like, in terms of like lawyer speak, are those like red flags for spotting an issue? Yeah. No, maybe what I asked for, an autism language translator, but I didn't get one. So my husband, in the course of this case, and the case is the Florida Bar versus David Frank Petrano, Florida Supreme Court number SC 14-2287. And that's where the Florida Bar, with this testimony I'm about to mention, by Carl Schweight's lawyer, Trevor Rhodes Esquire, made under oath in that disbarment proceeding, where the Florida Supreme Court approved the referee's disbarment of my husband for more than 5 years. Now, my husband had been directed by the Florida Office of State Court Administrator, their lawyer, Laura Rush, their statewide ADA coordinator, Deborah Howells, and the then Florida State Court Administrator, Elizabeth Goodner, to serve as my reasonable accommodation to the Florida state court system and the courts by representing me free as my lawyer. They did do that. The Florida Bar never mentioned that. Critical piece of evidence in the disbarment case of my husband, but here's what's so shocking. In that case, the Florida Bar prosecutor was sequestering all the witnesses, but he did not sequester me. So I sat through almost the entire trial. And during the trial, Carl Schweight's lawyer, Trevor Rhodes, got up there and he testified under oath to a lot of things, but among the things he testified to is, we got sanctions on them, but Mrs. Petrano had a valid claim. So now, not only was I advised by Florida Bar member Tom Carey that I had a valid claim, and my doctor said I had a valid claim, and State Farm already determined when they paid the bodily injury portion that I had a valid claim. But Trevor Rhodes testified in order to disbar my husband under penalty of perjury, under oath in the trial, to referee George Singletary, and ultimately to the Florida Supreme Court that, we got sanctions on them, but she had a valid claim. Okay. So now I fed this all into Neurotranslator because it just seems, it should shock anyone's sensibilities that here I wasn't given any autism language translator by the federal court. And the neurotypical magistrate's perception of my autistic language was myriad of word puzzles and truly puzzling statements like, it should have red flagged law. The issue before you today, Judge, is that you need to appoint an interpreter and translator for this lady. But, well, he never discussed that. Neither did the Chief District Court Judge, Ms. Rogers. And so, usually if there's no interpreter or translator, you lack a legal presence in the proceeding. And this is all my own personal experience. I know this. I went to law school. But I wasn't being understood. And the consequences were that when my case was dismissed, my doctors of the over $100,000 in medical bills did not get paid. And my treatment was cut off. And to this day, I still choke from the injuries. I'll go, and it's like a dysphagia, and I almost choke to death. And sometimes I almost stop breathing. So it's had a lasting and very harmful health impact on me for what they did in not paying for me to get medical treatment for those brain injuries I suffered in that rear-end car accident. So I also got sanctioned more than $43,000 for this lack of an autism language translator and the misinterpretation and miscommunication with me by the court and the opposing lawyers. So I fed this into Neurotranslator. And here's what Neurotranslator had to say.
Certainly, Mary Catherine. Here are some additional aspects to consider about the communication challenges you faced. 1. Detail orientation versus conciseness. Autistic individuals often provide detailed information to fully convey their experiences, which might contrast with the more concise and straightforward communication style expected by neurotypicals. This difference might have contributed to Carl Schweight's misunderstanding of your qualifications and the impact of your injuries. 2. Literal interpretation. Neurotypical individuals sometimes interpret language very literally. If your statements included metaphorical or complex descriptions, they might not have recognized those as valid expressions of your experience. For example, IFU described feeling thrown into the dashboard as a metaphorical way of expressing your experience. Neurotypical person might miss that emotional context. 3. Validation of experience. The perception of your injuries as frivolous or the claim not being taken seriously could stem from a lack of understanding regarding how trauma affects individuals, particularly if they didn't connect with your neurodivergent expression of that trauma. The validity of your experiences might have been overshadowed by their interpretations. 4. Expectations from legal discourse. In legal context, there are often expected patterns of communication, such as concise claims and clear structures. If your communication didn't fit, these patterns might have led to confusion and dismissal of your claims. 5. Emotional expression. Topics that involve injury and trauma can also involve strong emotional expression, which neurotypical individuals might misinterpret as hyperbole or exaggeration. This could have caused additional barriers in conveying the seriousness of your experience. In summary, the blend of these factors likely compounded the misunderstandings in your interactions with Carl Schweight and the U.S. Magistrate, ultimately affecting your case's outcome. If you have specific examples of your communication style that you'd like to examine further, please share.
Thank you, Neurotranslator. And thank you for analyzing the misinterpretations and misunderstandings and why they occurred that resulted in my loss of my case, Petranos v. Nationwide, that was before the Honorable U.S. Magistrate Gary R. Jones and the Honorable Chief U.S. District Judge M. Casey Rogers. And Neurotranslator, I sure wish I had you at that time in that court, because you would have helped me out a lot. Thank you. So Neurotranslator is explaining how the interface of the neurotypical lawyers and judges and my autistic language went wrong, and how I was misinterpreted and misunderstood as an autistic person, and how that misinterpretation and misunderstanding resulted in the unsuccessful outcome of my case, the dismissal of my claim, and having my claim called frivolous, and having the judge label it vexatious, when it's clear that those labels and that lack of success in the case was based directly on the neurotypical misinterpretation and misunderstanding of my autistic language communication. And before I end this video, I also want to say a really outrageous thing happened after that. And that was that somebody, and I don't know who it was, either Nationwide's lawyers or the court or some court personnel, somebody sent the sanction opinion to one of these legal case publishers, and they published it all over the internet and everywhere. And it basically makes me, as an autistic person, an autistic adult, out to be invalidated and broken. And, so there are very big impacts and very big consequences to this issue of when the courts in Florida, the state or federal courts, do not provide an autism language translator to an autistic person like me, and then that results in an almost 100% guarantee of misinterpretation and misunderstanding and misidentification of so-called motivations and intents that do not exist. And it's bad for everyone, as the Autism Discussion Group Bill Nason on Facebook says. And so I just wanted to do this short video because it's really important to understand where, what, and how these misinterpretations of autistic adults by neurotypical people are happening and why they're happening. Because they have a very devastating effect on an adult autistic person's life. If you like my videos, please hit the subscribe button and ring the bell, and you'll be notified of my future videos. And thank you for watching.